Is Dracula public domain? Have you ever wondered if the iconic novel Dracula is in the public domain? Let's dive into the fascinating world of copyright law to find out. Bram Stoker's Dracula was first published in the UK in 1897 by Archibald Constable and Company. To secure copyright in the US, authors had to deposit 2 copies of their work with the Copyright Office in the Library of Congress. Here's where things get interesting. When Dracula was published in the US in 1899 by Doubleday and McClure, it was discovered later that only 1 copy was deposited, not 2. This oversight seemed to put the novel into the public domain in the US. However, in 2013, a legal reference librarian at the Law Library of Congress found that 2 copies of the 1899 edition had indeed been deposited, contrary to earlier beliefs. Despite this, the novel's status in the U.S. remained complex. When Universal Studios bought the movie rights in the 1930s, they found out that the novel was effectively in the public domain due to the initial misunderstanding about the deposited copies. In Europe, however, the situation was different. Bram Stoker had properly registered his copyright in London in 1897, which protected his work. This is why Florence Stoker, Bram's widow, was able to sue the German film director Friedrich Wilhelm Murnau for copyright infringement over his film Nosferatu, which was based on Dracula. So, is Dracula public domain? In the U.S., the novel's status was murky due to the confusion over the deposited copies, but it was generally treated as if it were in the public domain. In Europe, it was clearly protected under copyright law at the time. Today, the novel is in the public domain in many countries because copyright laws typically expire after a certain number of years, usually the author's lifetime, plus a specified period. In summary, while the novel's copyright status was complicated in the past, Dracula is now largely in the public domain worldwide due to the expiration of its original copyright.